This is Rebecca Colton. I served as Chief Justice Arthur A. McGivern's executive assistant from 1987 to 2000. His oral history was done in two parts, one on September 4th, 2004 in Des Moines, Iowa. The other on September 2nd, 2005 in the Chief's namesake courtroom at the Wapello County Courthouse in Ottumwa, Iowa. The content of the interviews overlapped. The best parts of the two are edited and merged so that there is clarity and no redundancy. When he retired from the Iowa Supreme Court in November 2000, Chief Justice Arthur A. McGivern's judicial career had spanned 40 years and included service as an alternate municipal judge, 13 years as a district court judge, and 22 years as a justice of the Supreme Court. He was the longest-serving Chief Justice in the court's history, having served as Chief Justice for 13 years. While serving on the Supreme Court, McGiverin spent most of his working hours in the Wapello County Courthouse in his hometown of Ottumwa. After retiring from the Supreme Court, he continued to work in this courthouse as a senior judge, handling appellate motions for the Supreme Court, as well as doing the judicial work he enjoyed most, presiding over district court cases. In this oral history, Chief Justice McGiverin reflects on his life, his career, and the work of the courts. Like the county's namesake, Chief Justice McGiverin was respected for his wisdom, fairness, and integrity. Join us now for the oral history of Chief Justice Arthur A. McGiverin.
Friday, September 2nd, 2005. We're here in Ottumwa, Iowa, the Wapello County Courthouse, and more particularly in the Arthur McGiverin courtroom. We're here to continue the interview of Chief Justice Arthur McGiverin, which we started in September of 2004. Chief, thank you for inviting us down here. This is a beautiful courtroom, and before we start asking you questions about your life again, could you tell us a little bit about the courtroom?
Well, in March of 2004, the Wapello County Bar Association and the Wapello County Board of Supervisors dedicated this room as a so-called McGiverin courtroom. Previously, this had been a county law library for approximately 50 years. And we had all of the reporters from the various states around the country and the U.S. Supreme Court and so forth. And with computerization of legal research, this courtroom became a little bit antiquated, and also the cost of keeping up the books was quite large. So they moved the books out of this law library and made it into a courtroom. And it was somebody's idea, I guess, to perhaps dedicate the courtroom to me, and so they have my picture on one wall. But I also want to point out that on the other wall, there's a picture of Chief Wapello. And then Wapello County is named after him. And the story goes that Chief Wapello and myself will keep a good eye on the lawyers and the litigants to make sure they act properly in this room.
I see. And before we go, we'll take a closer look at the plaque and the nice portrait they have of you. So thank you for telling us about it. It's quite an honor, and we're really pleased to be here with you today. We want to go back a little bit and kind of create a pocket part to the interview we did earlier, if that's the word, and ask you a little bit about things that we talked a little bit about and things we may have missed the first time around. So let's go back first to the beginning of your career and exactly why you chose to be a lawyer and how you came about your choice in that matter.
Well, I'd always wanted to be a lawyer ever since the time I was in grade school. Some people may have thought that I liked to argue a lot, but I also was quite interested in civics and government and history classes. And so from grade school on, there wasn't any question in my mind as to what I wanted to be. That was to be a lawyer. And that's the way it finally turned out. Becoming a judge is another story, but I had to become a lawyer first.
And you had a choice, I take it, early in your career because you didn't have enough money to go to college directly, so you chose to go into the Army for a while. Is that right?
That's right. I graduated from high school, from McKinley High School in Cedar Rapids in June of 1946, and I had no money, but I wanted to go to college. And I was eventually the only member of my family of my 3 siblings that was able to go to college. World War II was just over, and so they still had the so-called GI Bill of Rights, which would help pay your way through college. And I joined the Army for a year and a half to be able to get the GI Bill of Rights. So that launched me into college, and I went on to other things.
And as I understand, what you told me earlier was that you had your career in the Army was such that you had a chance to stay in the Army as a regular Army officer. Well,
after I got out of the service the first time, from 46 to 48, I went to the University of Iowa, and then I graduated as an undergraduate in June of 1951. And I had been the cadet colonel and brigade commander of all the ROTC students at the University of Iowa, both Air Force and Army, during my last year. And the Army then offered me what was known as a regular Army commission, so that you could become a career Army officer, just as a graduate from West Point would be able to do. But I always wanted to be a lawyer. And so consequently, I had a crossroads career choice to make. And I decided to take a reserve officer's commission and not a regular Army officer's commission. I was called in as an infantry second lieutenant in September of 1951 as the Korean War was on. And I served for 2 years in the United States, in Japan in the 1st Cavalry Division, and over in South Korea for a couple of months, and got out in the summer of 1953. At that time I had earned some Korean War GI Bill, which helped me get through law school, so I was launched along that line.
And you never look back on going back to the Army at all, is that right?
Well, I always enjoyed the Army very much. I really have a soft spot in my heart for them. I was an enlisted man from 1946 to 1948. I became a big corporal then in the Signal Corps, and then I was eventually an infantry second lieutenant in my service from 1951 to 1953. The thing about my Army service taught me discipline, supervision, make sure a job got done right, and therefore I have a great empathy for the people in our armed forces now and what they need to contend with in their various duties.
So then, after you served in Korea, you went to law school at the University of Iowa and had Mason Ladd as your dean.
I did.
And as you were telling me earlier, Mason Ladd ran pretty much a one-man show with his secretary, Lucille.
Yes.
And can you tell us what law school was like when you came back from the service?
Well, when I came back from the service and started law school again, I'd gone to a summer session at the University of Iowa in 1951, so I had a summer session taste of law school before I went into the Army for another 2 years from 51 to 53. In law school, it was mainly an older group of men that were my classmates, and most of them had military service as I had had. There was only one woman in our class then. Her name was Dorothea Odine, unlike present times when perhaps 50% of the class are females. At that time, the University of Iowa Law School did not use the law school aptitude test for admission. Admission was only based on your undergraduate grades. So consequently, if you had decent grades, you could get into law school. The next question is whether you could stay in law school. And of course, they had the old saying then, and it was really quite true. When you were a beginning student, why they'd say to look to your left and your right, because in about a year, only one of you would still be here. Because people would either lose interest, they didn't want to work that hard in law school, or else they would flunk out for various reasons. So consequently, when I graduated from law school in June of 1956, there were probably about 70 survivors in my class that graduated then from the Iowa Law School.
And as a survivor and as a graduate, you took the bar almost immediately after graduation.
Yes.
And did you have a job by the time you were ready to graduate?
Yes, I had a job all during my senior year of law school. I had the luxury of that. I came from Cedar Rapids in Lynn County, but I decided that Cedar Rapids was probably too big a city for me. And I got an offer from a law firm in Ottumwa, Iowa, here, W.T. Barnes and Dick Slagle. And I might tell you they made an offer to me, a certain amount per month to go with them. and it happened to be $350 a month, which wasn't bad money at that time. And so before I accepted the job offer, I went to Dean Ladd to see what he thought about it. And of course, Dean Ladd always liked to make sure his graduates were placed someplace. And I told him about it. He knew W.T. Barnes and Dick Slagle, my future partners, and he asked what the job paid, and I told him, and he said, "Take it." And so I was launched eventually to a legal career here in Ottumwa, Iowa. And I practiced with W.T. and Dick in the Barnes, Slagle, and McGiverin three-man law firm from 1956 until 1965, when I became a district court judge.
During that period of time, most engaged in civil practice?
Yes, we had a general practice of law. It was civil. We did a few criminal cases, but mainly civil. We represented some insurance companies. We had some plaintiffs' cases. We had business clients and so forth, and I learned a lot more than I knew when I was in law school. I also want to say at this stage that I had very excellent partners, W.T. Barnes and Dick Slagle. They really taught me to be well prepared on cases. They taught me to be meticulous, to leave no stone unturned if you possibly could in representing your client. And those attributes help you in any walk of life, including being a judge later on.
There's one anecdote. I know you have some more anecdotes you're going to share with us, but maybe this is a good time to tell the one about your partner, W.T. Barnes. And I believe there's an anecdote about him and Kenny Keith here in Ottumwa, engaged in a civil trial before a judge, A.V. Haas, who was from Sheraton and in this district at the time. Could you tell us about that?
Well, my former law partner, W.T. Barnes and Kenny Keith, were both excellent trial lawyers here in Ottumwa. And I had them in court many times when I was a trial judge later on, but the story you're referring to was where Judge Haas, who was a very astute individual from Sheraton, was on the bench. And W.T. Barnes was on one side and Kenny Keith was on the other side. And they always used to accuse each other of various matters of malfeasance in connection with being unfair at the time, violating certain rules of evidence and so forth. And although they were excellent friends, they would get carried away with their own enthusiasm. They did in the instance where, in a given civil jury trial, both sides, due to alleged errors by the other side, moved for a mistrial. And Judge Haas said, "Granted." And they both were astounded, but they had nothing to appeal from. And so, with that background, when I was a trial judge here myself and I had them in court, or if any other lawyer was unhappy with some of my rulings and threatened to move for a mistrial, I'd say, "Please do it." Because they knew in the background about the Abe Haas story, and that I probably would grant it.
That story has lived long after it happened, and is part of the folklore of Southern Iowa courtrooms.
What was your first experience as a judge?
I was appointed by Governor Herschel Lovelace in January of 1960 as a part-time alternate municipal judge when Iowa had municipal judges at that time. Previously in Ottumwa, they had justice of the peace courts and police court, but they were melded into a new municipal judgeship that was formed effective in January of 1960 in Ottumwa. A problem occurred that the person that was appointed as the municipal judge in Ottumwa, William Dullard, was ill for the first day the court was supposed to be held in Ottumwa. So Governor Herschel Lovelace called down to my law partners, W.T. Barnes and Dick Slagle, and wanted to know if they could suggest anybody to be an alternate municipal judge in Ottumwa. I was the young associate in the office, and they looked around and said, "How about Art McGiverin?" And so I was appointed by Governor Lovelace, and then I was instructed to go the same day up to the courthouse and hold municipal court. So that's how my judicial career was launched.
Learning by doing.
I was an alternate municipal judge for from 1960 until 1965 when I became a district court judge.
Were you active in community affairs in Ottumwa?
I was in Ottumwa Community Players for several years. Yes. Not only as president of that group, but also as an actor from time to time. Also a stage manager, painting sets and various things, all the grunt work too. I also was active on hospital boards and some other community activities.
Did you have any interesting cases as a trial judge?
I enjoyed very much being a trial judge and serving on the Iowa Supreme Court. Both positions I think were great honors, and I was happy to serve. I basically like people, and I also very much respect people who work hard in their life. I think that being a practicing lawyer is a very difficult position, and I always respected lawyers, so I got along fine with them. I enjoyed so much going from one county to another. As a district court judge, I'd probably cover 8 or 9 counties during a given year as a judge in the 8th Judicial District based out of Ottumwa. And one reason I liked going from county to county is it was refreshing. You'd basically go from one world into another world. Now, our Iowa law is basically the same. Our lawyers are basically the same, except in each county they seem to do things a little bit differently. And I appreciated learning that and the challenges that went with it. There was a saying I usually had to the lawyers when I'd come in to a given county to make an assignment of cases before the start of a term of court. I would make the assignment and I'd tell them, now, I'm going to be here for 2 months. At that time, I'm probably going to be ready to leave. You're going to be ready to have me leave.
Did you enjoy being a judge?
Well, I always enjoyed the lawyers and the people very much, and I had the general philosophy always, if you treat other people decently, they will reciprocate. I also enjoyed very much working with court reporters who took down all the testimony. I enjoyed working with the people in the clerk of court's offices, juvenile probation officers, and everybody involved there. They're good people, and I enjoyed them. When I went on the Supreme Court in 1978, it took me a little while to get over the matter of being a trial judge. I eventually did get that, and then enjoyed work on the Supreme Court too, which is a different kind. When you're on the Supreme Court, the trial or the case has already been done, and the question is whether there's some wrong moves made by the trial judge during the course of that case. And as a trial judge, I could hopefully put myself in the position of the trial judge and what that person was confronted with, and understand what happened, and more importantly, why it happened. I enjoyed working with my law clerks. I had 20 different law clerks in the 22 years I was on the Supreme Court. There were men and women, married and not married, all very excellent people. And they all became my good and hopefully lifelong friends, and I still keep in touch with many of them. So I enjoyed my judicial career very much in working with people. I did not feel lonely or put off by myself because I kept enough contact with other people necessarily. Even when I was Chief Justice of the Iowa Supreme Court, I still kept an office in the Wapello County Courthouse. And I came back and forth between Ottumwa and Des Moines a lot. And I think it really helped my continued judicial education to have contact with people in the Wapello County Courthouse, even though I was on the Supreme Court. It helps you to continue to be a member of the real world.
What was your judicial philosophy when you were a trial judge?
I guess I'd refuse to categorize myself as a conservative or as a liberal. I guess I'd be more of an independent, really. But my approach to judicial and legal matters was, or a proposed decision, is to ask, first of all, is it compatible with the law? The second thing is, does it make any common sense? Now, if it doesn't make any common sense, you better go back and retrace your steps in the statutes and so forth like that and see where you come out. You may come out in the same place, but it really forces you to make sure that you've given a proper decision. I remember one time I had a case down in Bloomfield involving the Uniform Commercial Code. And that became new Iowa law effective in 1965. And I had a case involving a risk of loss, involving a coon dog, and some other things down there. It's a so-called Davis County case, but anyway. I traced, as I was trying to get my jury instructions together, I traced through the various sections of the Uniform Commercial Code. And the sections I found, the result didn't make any common sense. Now, I knew that very smart people had constructed the Uniform Commercial Code, so maybe I should do some more homework. And I did. And I found some other sections that were applicable. Because as you know, in the Uniform Commercial Code, there are a lot of definitions. You get one code section and you'll have a word that needs to be defined in some other code section which leads you to something else. Well, anyway, I think I got all the trail tracked down, and I finally got a decision in my own mind that made common sense. So that showed me that you've got to follow my old admonition. From the interesting standpoint, to me, was one that was known as the Lee County case. I was from Ottumwa in what was then the 8A Judicial District, and Lee County is over in the 8B Judicial District. The Lee County case involved an action by Lee County against the city of Keokuk. And this is about 1976 that this occurred. And Lee County was contending that there was only one county seat in Lee County. Although since Iowa became a state in 1846, they had always staffed an office for the sheriff, the clerk of court, and I believe treasurer in Keokuk. Lee County contended that only Fort Madison was the proper county seat for Lee County. The city of Keokuk, on the other hand, contended that there were 2 county seats in Lee County. And so I was sent in at great expense from 100 miles away to try this case. It was tried to the court, and the lawyers on both sides were very good lawyers. We went into the courtroom down in Keokuk. It was an old federal courtroom, as you may know.
Right.
It was in disheveled condition at that time before it was remodeled. And we had on one side of the aisle the Lee County Board of Supervisors, and they were all sitting there with their arms folded. On the other side, you had the Keokuk City Council, and they were sitting with their arms folded. And so lawyers went ahead and presented their evidence. A lot of it was by stipulation. And when the case was finished that afternoon, why I profusely praised the lawyers on both sides about their excellent job in front of their clients, of course. And then I packed up my suitcase and left town. I eventually filed a ruling that said that Lee County, in fact, did have 2 county seats. And if you get into the Iowa Code enough, there are statutes that back that up, above and beyond the custom that had prevailed for decades. And before I filed my ruling, the lawyers on both sides insisted they would appeal my ruling. And I said, fine. But they did not appeal my ruling. And so my ruling stands today. Lee County, Iowa has 2 county seats, one at Keokuk and the other at Fort Madison.
Now, could we talk about your time on the Supreme Court?
When I went on the court in 1978, there had been a substantial change in the personnel on the court. As I
remember, there were 3 right together.
Yes. In the summer of 1978, Chief Justice Moore, Justice Mason, and Justice Rawlings all had to retire under the age requirement. And so there are 3 openings for the Supreme Court. And I had been a district court or trial judge here for 13 years, and some lawyers decided that I should try for the Supreme Court. And of course, one's always honored when somebody suggests that to you, but at the same time, you always wonder if they're just trying to kick you upstairs and get rid of you out of the district court or not. But anyway, I tossed my hat in the ring in the summer of 1978. The Judicial Nominating Commission met in Des Moines for 2.5 days, and they had interviews with 53 applicants at that time. And I happened to be on the first panel of nominees with later Justice Robert Albee and a lawyer named Bob Tilden of Cedar Rapids. And Justice Albee got that first appointment in the summer of 1978. I happened to be on the second slate of nominees.
And as I understand it, they did not go back and re-interview everybody.
No, they did not.
It was a group of, they had a pool they were going to nominate from.
Yes, and after the governor made a selection from the first slate that was submitted to him, well, then they came up with another slate of 3, etc. And I was on the second slate with later Justice Jerry Larson of Harlan and Judge David Blair of Sioux City, and I got that appointment. And then eventually Justice Jerry Larson got the third appointment after I did. So he and I came on about the same time, within 10 days of each other. At the time I came on the Supreme Court in 1978, Chief Justice Ward Rendleston was chief. We had Bob Albee, David Harris, Clay LeGrand, Mark McCormick, Warren Reese, myself, Jerry Larson, and Harvey Uhlenhop on the court. And that was a very strong court. And I was kind of the new kid on the block then, and so I had a lot to learn, but they were great teachers. I might tell you one anecdote. You've probably heard several Warren Reese-isms along the line. The only one I'll report on is that Justice Reese at the conference table sat to my immediate left. He always had a twinkle in his eye, and even though we may have very serious conferences over cases from time to time and things would get a little heated, he always had some little joke or Reese-ism whereby he could just break everybody up and then they would no longer be quite so tense. Well, as a new justice and being the methodical individual I am, I always tried to make sure my votes on various Supreme Court cases were consistent with what I had done in the past. You can probably see what's coming, but anyway, I was cogitating on how to vote on a certain case along the line, whether that was consistent with my past pattern or not. And Reese winked at me and said, "Well, Art, consistency is the mark of a small mind." So what are you going to say? So I went ahead and voted on the case somehow.
Tell us what structural changes began when you went on the Supreme Court and continued while you were chief.
What you're generally referring to probably is the state funding of the district court system. And that's a many-faceted matter that happened over a number of years. When I went on the Supreme Court in 1978, as a justice of that, Chief Justice Ward Rendleston was, of course, the head of the court then. And he started working with the legislature to have the state fund the district court system. And eventually he got the job done with that. So the state would pay for the salaries of the district judges, the court reporters, the clerks of court, the juvenile court officers, court attendants, and any other court staff necessary. The counties had the fiscal obligation to provide the plant or the place for holding courts. So that was the general idea. A further selling point on state funding of the court system was to lessen perhaps the property tax burden of the counties. So that was the carrot at the end of the stick for the counties to go along with that. Before state funding of the court system in mass, as I just mentioned, occurred, there was a preliminary matter that I did have some hand in, and that was the funding by the state of district court administrators and case coordinators to assign the cases, which we take for granted now. Prior to the late 1970s, trial judges, as I had been, would come into a county and make the assignment of cases themselves, would monitor which cases might settle or drop out, and call up cases for trial when they would reach an order. The judge basically did that. The idea of district court administration was to relieve the judge of that responsibility and to handle the flow of cases completely and just tell the judge which case would be ready for trial on a given day. As I said, I had some hand in that aspect of it. At the time, there was a Republican senator named Frosty Schwengels of Fairfield, Iowa, down in our area, who was quite interested in this, as was Lowell Junkins, who at that time was a Democrat minority leader in the Senate. And so I had meetings with them and another friend who was a court organizer. And eventually, the legislature did pass and make funds available for district court administrators to be paid by the state and be in the 8 different judicial districts. So that was kind of the first step in connection with court reorganization. After that, during the 1980s, under the leadership of Chief Justice Ward Reynolson, the state eventually funded all of the aspects of the district court system, as I mentioned before. Chief Justice Reynolson resigned in 1987, and I became Chief Justice, and so I was involved in putting the meat on the bones of various aspects of the theory of the state funding all of the district court system. And the state didn't do that all at one time. They did it in segments. You'd have the court clerks one year, the juvenile probation officers another year, and so forth like that. Of course, there were many personnel problems that had to be coped with from a fair play standpoint. You had various clerk's offices of various sizes around the country, or around the state rather. The question would be, how would you fairly pay each of those clerks of court? And about the same time, we had the concept coming in for consideration of comparable worth, which is a theory that you'd evaluate as with different types of jobs, how much are they worth compared to each other? And so that was another personnel and fiscal matter that we had to cope with.
As Chief Justice, during this time of implementation, how much of your time was spent doing that, Your Honor?
Well, I never really kept track of it from that standpoint. I always liked the challenge of administration, so I had no problem in doing it. I'd say maybe perhaps a third or a fourth of my time, but was devoted to what I call administrative matters. The rest of the time I had kind of my first love, and that was the preparing for and deciding of cases. Lots of times that would be less of a headache than the administrative matters might be.
Did your load doing that part of it, deciding cases, did that get reduced because of this load on the administrative part of your job?
Yes, it did. I tried to handle the same number of cases for opinion writing as the other justices for a while after I became Chief Justice, and then I reduced my caseload by one case per month as far as how many I would write. The practical problem was that as Chief Justice, you sometimes have speeches to give to various organizations. That requires time to prepare those speeches, to actually get ready for them and actually giving them. And the candle got burned a little bit short from time to time, so consequently I did reduce my caseload a bit from what the other justices did. At the same time, I wanted to do what I thought was my fair share of them, so you keep your hand in. And not only is it the more enjoyable part of the job as a justice, but also it helps keep the respect of your fellow justices if they perceive that you're carrying your fair load.
How many opinions were you writing on average each month? Do you recall?
Well, I would take 2 for writing myself. The other justices normally took 3 and maybe more. Also, if you felt so strongly in a case that some other justice was writing an opinion on, you may want to write a dissent. But with the demands on your time, you'd have to feel very strongly before you'd write very much on a dissent.
Now, in addition to all this, there's a motion practice that goes on in the Iowa Supreme Court. Is part of your time taken up with that as well?
Indeed there is, yes. There are a number of appellate motions that are filed by lawyers, as you well know, before a case is ready for actual submission or decision by the Supreme Court. It may be, for example, a motion to dismiss the appeal completely on the theory that the other side didn't comply with some rules. It may be a motion to strike a portion of the other side's brief or appendix for some reason that supposedly makes it improper. There's just a number of things that are brought to the attention of the Supreme Court that has to be ruled on before a case is ready to actually be heard and argued and submitted. When I was on the Supreme Court, all of those motions were handled by one of the sitting justices. And one reason was because we didn't have any senior judges as we have now. And I am a senior judge now since I retired in November of 2000 from the Supreme Court. And a lot of those motions are now submitted to senior judges for ruling, which is something we can do to help the Supreme Court, the sitting justices, and not take their time so they can better apply themselves to the cases that are submitted to them. And that's what I do now. It's a lot of my motion practice is what I do to help the Supreme Court as a senior judge. And Justice Andreessen, senior retired justice, does that also, and so does Justice Snell. Justice David Harris, who's now even retired as a senior judge, used to do that, and so did former Justice Schultz. So that does help the court and lets them concentrate better on cases submitted to them.
Can we talk a little bit about your judicial philosophy? One of my partners, John Mackman, always said the worst thing that could happen to you in the Iowa Supreme Court is to lose 5-4, in his time anyway, that the contract was not ambiguous. And I wonder if you'd share with us what you felt the role of a Chief Justice might be in that, and your other judicial philosophy, if you will, about do you try to persuade justices to come your way, or because you think that it would look better for the court that if the vote was different, even though there was, say, a majority already formed? But tell us a little bit about how you thought that all that ought to work and what you did.
Well, as Chief Justice, I really regard myself more as a chairman of a board, and I never tried to influence anybody on any decision on any case. I frankly thought that would be improper as far as trying to lobby another justice on the case, and that was the general climate of feeling on the court. One justice would not try to lobby another. What could be done, of course, would be to discuss the reasons for your views at a conference of all of the justices of the court, which we would have at least once a month on all of the cases, whereby you would state your position, the reason for it, and so forth, and hope that your arguments at that conference of all of the members of the court in one room would be persuasive to cause people to vote your way on the thing. Something we did not do was go to another justice's office to try to persuade them or lobby them to come your way. Now, sometimes there might be conferences between two justices to work out the given language on an opinion to accommodate somebody, their views, but not as far as lobbying them to vote completely one way or the other. That would frankly be resented by the justices in my view. So if what you're getting at is whether we did something like Chief Justice Earl Warren supposedly did before the decision of the U.S. Supreme Court in Brown versus the Board of Education of Topeka, Kansas, to get a majority vote or a unanimous vote in that case, we did not do that.
As you know, the legislature sets judicial salaries. Even so, did the court advise the legislature on them?
Yes, there was always a legislative advisory committee that met every couple of years or so. And I would make a presentation, as would whoever was the current president of the Iowa Judges Association, would make presentations about judicial salaries for Iowa. We had stats from other states and the National Center for State Courts as to what other states were paying in comparable positions. And we would make a substantial effort to let the people know our situation and have them make recommendations, hopefully favorably to us, to the legislature. That always was another matter that we would address, not only in my annual address to the legislature, but also with legislative leaders on a one-on-one basis, the majority leaders of the Senate and the House, and also with the governor. And Governor Branstad was the governor when I first became Chief Justice in 1987, and he was always very supportive also. And so that's one thing you need to work on, but at the same time, as Chief Justice, you have to also be quite cognizant of the salaries available for the other judicial staff, because it's the staff that makes judges really look good as far as having the files up to date and everything the way they should be to allow judges just to concentrate on trying cases and deciding them. So judicial salaries, but I'd say salaries for all of the court system personnel was the concern. And we worked on that all the time.
You've talked about it in two different ways, but not directly on point. There is an annual message you give to the legislature that the Chief Justice gives, which I would call a State of the Judiciary. And you mentioned you had to give speeches, and you mentioned now that that was one of the topics you'd raised with him. How important was that speech? And you had to give it in your tenure several times, I think. So tell us a little bit about doing that. Was that an important part of your role as Chief Justice?
It was. I gave speeches to the legislature from January of 1988 through January of 2000, the year I retired. And that was pretty much an update to the legislature as to the state of the judiciary. How we were doing, what we needed, of course, to thank them profusely, hopefully, for anything they had provided us in the past, and just maintain the presence with the legislature. That was so that all of the legislators would be able to see the Chief Justice and the court and become cognizant of the judicial branch of government. And the speech was always on the beginning of the legislature and the day after the governor had given his State of the State address. And then we usually invited all the legislators down to our Supreme Court chambers for coffee and cookies and a little smoothing along that line, and perhaps we might lobby them a bit at that time. And so that was one thing we did, and deciding what you're going to talk about in that speech and how you're going to craft it was like building a house almost each time. I'd probably start in October or November on possible areas of subject matter to talk to the legislature about, as we kind of knew what our problems were and what we wanted to present to them. And consequently, we would build it up like a crescendo till we finally gave the actual final product in early January of each year. Now, another thing that we did to kind of help the presence of the judicial branch with the legislature was always made a point of talking to the group of new legislators each time they came in every 2 years. New persons coming to the House and the Senate, and tell them what the judicial branch is all about. We would not have any long presentation, but at least let them know and introduce them to the court administrator, the person who probably would be doing the liaison or lobbying for the judicial branch up there and so forth, so that they would get to know about us and then feel more comfortable when they heard our main address to the legislature.
Now, you use that word, the L word, lobbying. Can you tell us about what does a Chief Justice feel comfortable doing about what other people might call lobbying?
I'd say just present the facts. I'm a pretty straightforward individual. If I came to you and you were the majority leader of the Senate or the House or something, I'd tell you what we needed and why, and I would ask you to please do everything you can to help us. Now, you can call that lobbying, you can call it direct contact, or whatever you want. That's what it'd be. See, we had, in the judicial branch, we had no money to be able to put into the campaigns of the various members of the legislature, and they knew that. So we didn't have much power from that standpoint. All we could do was point out we're a part of the third branch of government, that we rely on the legislature for funds, and here's what we need and why.
Tell us a little bit. You told me earlier that you served with 17 different justices.
Yes.
And I'm sure you'd have lots of stories, maybe some of them not ones you'd say publicly about all these individuals that you serve with, but I assume you had a high regard for all of them, and if you'd like to share anything about any of them, we'd love to hear it.
Well, I enjoyed very much working with all 17 of the justices. They were very different in backgrounds. They were all very excellent students of the law. They were well prepared on their cases, and whether I agreed with them or not, I always respected their opinions, and that was reciprocated too.
Your mention of the fact that 3 justices were appointed all very close to each other. Did the sequence of those appointments, did that make a difference in your career on the Iowa Supreme Court at all?
Well, it made a difference, but not a substantial one, and I'll tell you what I mean. Justice Robert Albee was first appointed of the 3 vacancies in 1978. So he had seniority over myself, who was appointed second, and then Justice Jerry Larson, who was appointed third. And when the first time the Supreme Court actually sat on cases was in September of 1978, when we had hearings out in the courtroom for cases. At that time, I had 10 days seniority over Justice Larson, so that meant that I sat on the right edge, far edge of the court, and he sat on the left. The most junior member always had to sit over on the far left side. So I started right out on the right side of the court, and then worked my way
with
up
some seniority.
Yeah.
Okay. Well, I won't push you for more anecdotes out of that group, but I think you have some anecdotes you want to share with us later anyway. Chief Justice, I think we talked last time about the changes that you've seen, but I'd like to give you an opportunity to talk about that some more. And would you like to tell us about the changes you've seen in your years, both as a lawyer and as a judge?
Well, there's a long catalog of things that have occurred that I might mention from the time that I first started practicing as a lawyer and a judge. I suppose a place to start out would be that in 1963, when Iowa had passed a constitutional amendment to provide for the merit selection of judges. This was the so-called Missouri plan, or merit plan on selection of judges. Previously, judges would run on a party ticket, Republican or Democrat or whatever it would be, for the office of judge. And that would involve perhaps some campaigning if along the line, but they were elected on a party ticket. The idea on the merit selection plan was to have a nonpartisan panel submit a list of nominees to the governor for appointment for vacancies on the Supreme Court. And that was passed in approximately 1963 and became effective on July 1, 1965. As I may have mentioned to you, I was a district court judge appointed by Governor Harold Hughes, effective on that date under this new plan. At that time, I was 36 years old, and the judge I was replacing was age 90, Judge Elmer K. Doherty of Ottumwa. And he had to retire as of that date because the legislation provided that anybody over the age of 75 had to retire then. So that's how the vacancy occurred here in Ottumwa. Another change down the line, that was on the selection of judges. Another changing was in 1972, when I was district court judge, Iowa had a redistricting of districts down from 18 to 8 judicial districts. And southeast Iowa became what's known now as the 8th district. So that was a change. At the same time, there was an establishment of a judicial council, which is an advisory group to advise the Supreme Court on various matters of court administration throughout the state. And that was composed of the 8 chief judges of the districts I mentioned, the Chief Judge of the Court of Appeals, plus the Chief Justice of the Iowa Supreme Court. So that was a change from an administration standpoint. As we mentioned earlier, another change was the matter of state funding of the whole court system, rather than it being largely financed by the counties from property taxes. And this was accomplished, of course, during the 1980s.
Just so we know the context of this, Judge, before the change you speak of, a county would elect a judge. Is that how it would work?
No, there would be a district that would elect a judge.
Elect a judge,
yes.
And if you didn't get along with that judge, you're pretty much in trouble, aren't you?
Yeah.
As a
and
lawyer.
There would be just maybe a few judges in a given district on the thing, and with the change from 18 to down to 8 judicial districts, there were more judges in a given district, and consequently the judges would travel from through a number of counties during the year. And that prevented what you're alluding to as so-called home cooking, whereby there'd be a certain judge in same county all the time, and the judges would be, and the lawyers would be stuck with that person or not.
Okay.
Depending on your philosophy.
Of course. Thank you. I think for people who don't understand the background of this, I think, because I think this is one of the most important changes we've done in Iowa in helping the judiciary and creating a much a fairer atmosphere, I think, is what I'd call it. But is that, I don't know if you agree with that or not, but I think it was a good step forward.
Oh, I definitely agree with you. No question about it. And as I mentioned earlier in this interview, I enjoyed going from one county to the other
Yeah.
for the reasons I mentioned.
Okay.
Now, another big change, of course, we hadn't talked about before, is that starting in 1980, we had cameras in the courtroom. The Supreme Court had established a statewide commission chaired by Justice Jerry Larson of our court to study the matter of cameras being in the courtroom. And we've had them for the past 25 years without too many bad incidents as far as I know, but that's been as a result of the work of the judges, the lawyers, and the media coordinators that we have appointed in various areas of the state. This was a big project by the Freedom of Information Council of Iowa at the time, and they have followed up to have, I would think, responsible media coordinators in each of the areas to work with judges so that cameras can be in the courtroom and video trials or parts thereof, but not interfere with the rights of either party to have a fair trial. I was quite dubious about this situation, frankly, when it first started, but it worked out very, very well. I became a fan of it. In fact, I might mention that the Freedom of Information Council is having a meeting, I think, this September to celebrate 25 years of successful cameras in the courtroom of Iowa. Another thing that has changed over the years is that the institution of time standards for disposing of cases in district courts. By that I mean there's a time standard that all civil jury cases are supposed to be disposed of within 18 months and all non-jury civil cases within 12 months. Now some districts have put tighter clamps on than that on the matter. But that was a change from what used to be the practice when I first started to be a district judge.
Now, were you part of the system that implemented that? Where were you when that happened?
I was on the Supreme Court when that
That's
happened,
what I thought. Yes,
yeah.
sir. And that time frame, I think, is all, at least as someone like me who practices, has been a very helpful thing in getting cases moved along to trial. I think has been a remarkable step forward, I think.
Well, when I first became a district judge, I had the theory that every litigant was entitled to have their case tried within 6 months after it was filed. And if it was on appeal, it should be decided within 6 months. Now, I realize that's an ambitious time frame, but from the standpoint of the litigant, whether I'm being sued or I'm suing somebody else, I want to get it over with, and the sooner the better. And I thought other people were entitled to the same theory.
Tell us a little bit about that. That reminds me a bit. When we did Justice Albee, he recounted the days in Polk County where every fall there would be a giant, what I'd call cattle call of all the lawyers who would come, and they would set the docket for that term. The courthouse wasn't air conditioned in the summer, so they did not try cases in the summer, but it's sort of what I call the school year. They try cases. Now, when you were on the district court and you came in to serve in a certain county for a particular time, what would you do about setting trials? Would you have a conference of all the lawyers that had cases pending that needed, or how would you go about setting up your docket for the period of time you were a judge in the county? Yeah,
this was before the days of having district court administrators, of course, to do that. I would usually go to a given county, say Washington County in our district. I'd go there 2 weeks before the beginning of my term of court in Washington County. And I would make an assignment of cases then. And at that time, then the clerk's office would type up the assignment I had made, send it out to all the lawyers. So when I'd come in on the first day of my new trial session, they'd be ready to go. And that's how it worked then. Now, we didn't have the numbers of people that Justice Albee's talking about of a cattle call like in Polk County, but the same principle would apply even in the smaller counties.
And did that work pretty well?
It did. It did.
And were you a tough judge you get a continuance out of?
Some would say that.
Okay.
If I was ready, you should be ready.
Yes, sir.
Another matter that's kind of changed a lot over the years, I think, is a number of cases submitted to private and to court mediation. This did not happen when I was a trial judge usually. I would get the lawyers in the office and ask them if they'd exhausted their settlement efforts in this case, and if they said yes, why we'd go out and try it. It was just that simple. I would not try to jawbone them or twist their arms to settle. My court reporter might do that sometime, but I didn't. Along that line, I had Judge Doherty's court reporter when I became a judge in 1965, and Art was a very nice, short person who also was a Penn court reporter. At that time, all the court reporters in our district were Penn men. They were all men, and they all were Gregg shorthand reporters. And Art Dorothy had a knack, which I didn't fault him for, of going around to the lawyers on both sides. He'd come up to you first of all and say, "I think you're going to lose." And in substance, he'd go over and type the same to the other along the line. Then maybe he'd get them to talking and come back in, and pretty soon he'd be rubbing his hands. He said, "I think we got this case settled." No, I hadn't done a thing.
Now, was he your court reporter your entire time on the trial?
No, Art was my court reporter from 1965 to 1972. And then he retired, and I had other reporters after that.
Anyone you'd like to mention here?
Well, Art Dorothy of Keosauqua, I mentioned certainly.
Now, was he in any relation to the Dorothy and...
Yeah, he's the father of Art Dorothy, or I'm sorry, of Jim Dorothy, who was a lawyer down at Keosauqua, yes.
Okay.
He's his father, and Jim Dorothy is retired now, too.
Yes, okay.
And I had other court reporters. A fellow named Don Souther was with me for several years, and then my last court reporter was Julie Tonda from Knoxville, who was a reporter for Judge Dick Vogel, and I think she's now up in the Polk County District now, something like that. Another change in the court system, of course, is the obvious one, the need for interpreters. We've not only had a number of Hispanics move into Iowa and Wapello County, but people of other nationalities too. And of course, something we have now available, especially for our magistrate court judges, is a phone-in type of system where you can phone in to some certain number and they can get an interpreter for you in almost any language on the line pretty soon and help you in connection with your case involving some foreign national. So that's a huge thing that has occurred necessarily since I started being a judge. Another thing like we're doing right here is the advent of video conferencing. On criminal arraignments, where you have the magistrate, as we have downstairs in this courthouse and over in Polk County, I think, will conduct an arraignment or initial appearance by a criminal defendant by video. And the sheriff's office does not have to bring that individual with the security problems it may entail over to where the judge is located. Also, video conferencing occurs now, as I understand it, like in post-conviction relief cases, where there's a post-conviction relief petition, and the criminal defendant can be like down at Fort Madison at the penitentiary and be involved in the hearing in Polk County by video. So that is a decided change in how we used to do things.
Did the Supreme Court use telephones or some system to conference without having to meet every...
Yes, we did, and we used telephone conferencing for various matters as far as deciding which cases we might keep or which cases we transfer to the Court of Appeals, and on some various routine administrative matters. Yes, we'd use telephone a lot.
Any other things you'd like to tell us about here? This is your opportunity to make sure that I, as a questioner, haven't forgotten something here.
Well, just one short thing, that I think there's been a recent decline in the number of civil trials. You'd probably know about that better than I would. I think that's probably due to maybe fewer cases being filed, and also due to mediation and arbitration that parties seem to be going to more and more. One, it gets perhaps a quicker resolution of the matter, and also there's question of the high cost of litigation, which is. Lawyers need to be paid and are paid, hopefully, and that costs money. So consequently, we do not have as many civil, especially civil jury cases tried as we used to. And in fact, there's almost a philosophy that I think has occurred that perhaps the system has failed if a case actually gets to trial before the court. The theory is it should be settled, and that's for other people to decide as to the merits of that.
There was some talk with Justice Albee about in the conference room that you sat in the chair of the judge you replaced. Is that?
Yes, that is true. There were 9 chairs around the conference table in the Supreme Court conference room, which was right back of the Supreme Court room. And you supposedly inherited the chair of your predecessor, with one exception. Let's see. Chief Justice Rendelson had been sitting where Justice Albee eventually did, and he went up to the head of the table as Chief Justice. Albee came in and took Rendelson's chair at a certain spot, and I believe I took Justice Mason's position on his chair, and Justice Larson took former Justice Rawlings's chair.
Well, that's a good seat to fill.
And so with that sequence, that's how I wound up sitting right next to Justice Warren Reese of Anamosa.
Okay, thank you. Let's talk a little bit about the anecdotes. We've shared one that we did about Judge A.V. Haas. Would you like to share others about your time on the bench?
Well, these mainly come from my service on the Iowa Supreme Court. And as you may know, Justice David Harris was the unofficial court historian for the Supreme Court. He is quite an expert in connection with the early justices and can pull down Iowa reports and tell you all kinds of things about them and their time. He also was quite a poet, as you well know, and he would write a jingle or a poem about each or many cases that we heard out on the bench. We'd be hearing arguments and he'd be scribbling away on something, so we knew he was up to writing another one of his jingles. We get back in the Iowa Supreme Court room, and we'd all want to have him read his jingle to us. And of course, another justice might have been assigned to prospectively write an opinion on a given case and would report on the facts and probable law and so forth. We wanted to hear Harris's jingle. And amazingly, Justice Harris would always get right to the real meat of the case, and in a very few words express it much better than any of the rest of us could laboriously have an opinion on. So he was really missed after he left there.
Important cases while you were on the Supreme Court, memorable ones you'd like to tell us about. You told us about the one in the district court, I believe, the fight over whether or not Lee County could have 2 county seats or not. Mm-hmm. What about cases when you were in the Supreme Court? Are there memorable ones there you'd like to tell us about?
Oh, there's one that does stick in my memory, although we had a lot of important cases probably, and that was the so-called ASME case. That's where the Union of the Iowa Workers,
the state workers
sued Governor Branstad and the Iowa legislature to require them to appropriate money to honor or pay raises that had been previously negotiated by that union with the state of Iowa for the workers for the next 2-year period. And that had this bargaining contract had been entered into under Chapter 20 of the Iowa Code that provides for collective bargaining with state public employees. Well, at the time in question, which is back in the 1990s sometime, we had some hard economic times, and the legislature basically said, we don't have enough money to be able to fund this contract, and we're not going to do it. So they got sued by the state union. So the question was, as I posed, must the state honor its contract or not, due to the economic times? And the Supreme Court heard substantial arguments on that, and finally decided, yes, the state must honor its word. Just like if I give you my word as my bond, if I enter into a contract with you, I am supposed to keep it. And so we ruled the state had to appropriate the money to honor the contract. Now there was a time, of course, after that. The members of the legislature were probably not too happy with the Supreme Court, but it was an instance, once again, of an exercise of judicial independence, whereby the court did what it thought was correct under the law and the Constitution and held accordingly.
I suspect that was the kind of case that moved quickly through the court system and had to be done on an expedited basis?
Yes, it was. It was.
And what kind of pressure does that put on a court like such as the Iowa Supreme Court? Is it?
Well, we rose to meet the challenge, and we'll do what we need to do. And we did have an expedited moving of that case. Justice David Harris wrote the opinion for the court. I was interested in the matter too, and this was an instance where I probably did help him with the wording a little bit from time to time. But I was of the basic view as he was, that the contract should be honored. So one justice would work with another on language on an opinion, but not try to influence the other justice on how the case ought to finally be decided.
Tell us about your family.
My wife Joanne and I were married in April of 1951, and she's been a very good supporter of mine and a very stabilizing influence over the years. We have 4 children who range in age from 40 to 47, I believe it is, and they're spread to the winds to Puerto Rico, Ames, Bartlesville, Oklahoma.
And their occupations or careers?
Our oldest, Teresa, is she works for the U.S. Department of Agriculture in Kansas City, Missouri. She's into computers, things I don't understand. Our son Tom works for Iowa State University up in Ames. Our son Bruce is a lawyer down in Puerto Rico. He's been there since 1988. And our daughter Nancy lives in Bartlesville, Oklahoma, and she has a daughter who's a fine tennis player, I think.
Now let's turn to your wonderful statements you have here, and I believe these are quotations of lawyers speaking before the Iowa Supreme Court. Is that?
Well, and also sometimes by judges.
By judges. Too. Okay.
I have one. I didn't jot them all down, but one that comes to mind is there was a musing by an Iowa Supreme Court justice after an oral argument, and he's referring to a lawyer who said, he can put a lot of words into a small thought. Now, I won't mention the name of the justice on the thing, but he's still on the Iowa Supreme Court. Another time we had a lawyer from Knoxville, and this was really a former congressman, the clue I'll give you, who represented a defendant in a criminal case. And he was asked by one of the justices from the bench on appeal about a procedural problem in the state's case. And the defendant lawyer said, "It's not my job to convict my defendant or to help the prosecution make its record." Another one occurred when asked by a justice on appeal about the legislative intent concerning a statute. And this lawyer said, "I have not consulted any legislator this morning. Therefore, I have to rely on what's written in the code." This attorney had been in both the Attorney General's office and the Public Defender's office, and was an excellent lawyer. We had another instance in the Supreme Court. There was a petition for rehearing in a case. Now, once we issue a decision or an opinion on a case, that's supposed to be the final decision, but lawyers do have the right under the rules to file a petition for rehearing and ask the court to, again, to find their way or to point out some error in the court's opinion. So in this instance, in a petition for rehearing, it was in a case in which Justice Harris wrote the opinion for the court. And the petition stated in substance that Justice Harris was wrong on all issues in the case, except for those that he had overlooked. Obviously, this writer knew how to charm the court.
Yes. Win friends and influence people.
Another one was, this was by a Des Moines lawyer. This will probably be my last one here. And once again, I won't mention the name to protect the guilty. The lawyer said, in the wind-up, having addressed these 4 arguments, I have told you all that I know, and perhaps more than I know, and therefore I will rest my case.
Yeah, that's very good. Tell us a little bit here in conclusion as to, I think you kind of a wind-up. I have tried mightily in this interview to get you to kind of take credit for some of the things you've done and in this thing, and I find you be one of the most self-effacing judges I've run into. But tell us a little bit about how you think things were accomplished in your career, and who you feel you owe some things to, at least in how you ended up the way you are here.
Well, as we've cataloged before, there are many changes that occurred in connection with the court system and issues over the years, and whatever was ever accomplished, in my view, was always a team effort by a number of people. If you had good people who would apply their minds to various things, if they had trust and confidence in each other and in you, and cooperated with each other, these were the keys to solving any solution. So many things can be pointed to, or perhaps credit extended, but I always took the view that it didn't make any difference. It was not important who got credit on things. The question was, get the job done. And if you treat people, as I said, with respect before, they treat you with respect, you work together, and you get the job done.
Thank you very much, Justice McGiverin. I want to say, just for the record here, that you were my first victim, and you have borne it very admirably, and the fact that we've come back and finished up a little bit more today is, I think, a testament to your patience with us in this matter, and I want to thank you very much for participating in this program. You've been really a pleasure to work with. Thank you very much.
I want to thank you and the Bar Association for this, I think, very, very worthwhile project.
Thank you.
10 seconds of this?
So we all look forward.
Yeah. Smile.